Good afternoon, all. I'm pleased to be joined here today by the Privacy Commissioner, Mr. Alexander White, and Dr. Marissa Stones. The Privacy Commissioner and I are delighted to provide an update to the community regarding the steps that we are taking to prepare Bermuda for the Personal Information Protection Amendment Act 2023. We live in a data-driven world, and since the pandemic, we have become more and more dependent on operating in an online space. Personal information permeates businesses, private and public sector organizations, and workplaces, including names, addresses, personal history, contact information, medical and financial data. This information may be readily available online or easily accessed in other cases. Personal information, in most instances, must be protected because if it falls into the wrong hands, it could be harmful to the individual and to the organization. Depending on the situation, individuals could become victims of identity theft, discrimination, physical harm, harassment, or the victim of libelous and defamatory communications. Organizations may find their reputation affected or may be legally responsible. In this explosive digital age, this government is committed to ensuring that all its citizens are treated fairly and appropriately protected. In that regard, the public will note that the Personal Information Protection Amendment, PIPA Bill 2023, was tabled in the House of Assembly on June 2nd, 2023. This bill seeks to amend the Personal Information Protection Act 2016 to make significant amendments to the Public Access to Information Act 2010 and the Public Access to Information Regulations 2014. Essentially, the bill seeks to harmonize the PIPA and PADI legislation, which moves the government a step closer to implementation of PIPA. Tomorrow, we will be debating this matter in the House, and I wanted to provide an opportunity to share with the public a little bit of why this legislation is so critical and why it matters to residents and businesses. It's important to understand that privacy legislation, also referred to as data protection or informational privacy, provides for an important human right and forms a critical building block in the creation of a successful information society. The aim of the PIPA is to put the control over the use of personal information into the hands of individuals. Privacy is often confused with the public access to information or freedom of information. They have similarities, but are quite different. PADI gives the public the right to obtain access to information held by public authorities to the greatest extent possible, subject to exceptions that are in the public interest or for the protection of the rights of others. PADI's purpose is to inform the public about the activities of public authorities, including the manner in which they make decisions. The Personal Information Protection Amendment Bill will resolve overlapping provisions currently found in PADI and the PIPA regulations, PADI and the PADI regulations 2014 with the PIPA to ensure, for example, one definition of personal information and one legislative regime to request and correct one's own personal information. The amendments primarily allow personal information requests to public authorities to be managed through PIPA and not PADI once PIPA comes into force. With the anticipated passage in the House of Assembly of the Personal Information Protection Amendment Bill 2023, I can advise that PIPA will formally come into force on January 1st, 2025. I recognize that PIPA can seem like a daunting prospect for our community. And admittedly, there is much to consider when it comes to what is required and what the public's responsibility is as it relates to privacy and the protection of personal information. I can assure the public that much work has gone on to prepare Bermuda for PIPA. As an example, the Privacy Commissioner was appointed in January 2020. The Office of the Privacy Commissioner will be responsible for monitoring the implementation of PIPA and using his powers, as stated in the PIPA, for its management and enforcement. As part of the Privacy Commissioner's road to PIPA, Mr. White has also been very active in issuing guidance, offering extensive training, and working with industry groups to help them understand the requirements and to ensure their adoption of PIPA. The Privacy Commissioner will continue working across the community with businesses to help ensure the smooth transition. In particular, we want to stress that we are sensitive to our small businesses, entrepreneurs, and medium-sized businesses as we prepare for PIPA. And I can assure them that special assistance and guidance will be provided to make sure they are ready. In fact, the Privacy Commissioner will provide user-friendly resources that may allow them to manage privacy themselves. Finally, I should point out that PIPA is designed to meet international best practice, and many of Bermuda's competitors already comply with data protection and privacy provisions, including small jurisdictions such as Gibraltar, the Isle of Man, Jersey, and Cayman, amongst others. Furthermore, the European Union requires companies that conduct financial services in the EU to have this legislation. In the United States, recent laws like the California Consumer Privacy Act are also in line with this legislation. And with the implementation of this legislation, Bermuda will join other international destinations in becoming a country that falls within the network of trust. Tomorrow, I will lead the parliamentary debate in the House of Assembly on this critical piece of legislation. I encourage the public to tune in so that they can learn more about the steps that this government is taking to ensure that their rights are protected. I'd now like to invite the Privacy Commissioner to share with you the steps his office will take over the next 18 months to support the business community in preparation for PIPA. Thank you.
Thank you, Minister. It's an honor to join you on stage today, so thank you very much for this opportunity. So with this announcement, we now have an 18-month window for organizations to prepare for PIPA. This course of action has my support, and we've worked closely with our government colleagues in developing this implementation window. With this fixed universal date, we can provide legal certainty to the community and avoid confusion about deadlines. With this 18-month window, we can also provide organizations with the notice that they need, and our office can guide them with a phased action plan over this course of time. Our office will be working with businesses large and small to help ensure a smooth transition. We have a variety of resources already available on our website and other places, such as a video training called Privacy and PIPA, which goes over the basics, more detailed written explanations on key topics like what is a privacy program, what is a privacy officer, What do those officers do? And how can individuals in the community pursue privacy compliance and ethics as a career? In addition, we talk about transferring information to third parties, whether a third party in Bermuda or abroad. We have basic cybersecurity tips and guidance on privacy harms, particularly for vulnerable groups like children or the elderly. And we even discuss the return on investment that you can get from a privacy program, so that businesses don't necessarily need to think of it as a cost and not a benefit. In addition to these existing resources, we have in-person training events already scheduled and more to come. Right now, we have a Road to PIPA series where we have cohorts of organizations that are working together on a 6-month plan to implement a privacy program. We'll use the lessons from those cohorts in order to create feedback for the community as a whole to benefit from. Also, our Pink Sandbox continues to work with organizations who need custom guidance as part of our office's Innovation Services program to encourage organizations, whether already in Bermuda or looking to establish themselves in Bermuda, to be creative and innovative while still meeting their compliance obligations. More recently, we have announced a partnership with the UK-based IASME consortium to adapt their privacy and cybersecurity certifications to Bermuda. The audit and certification program that they offer is oriented towards small businesses and has been very successful in the UK in helping small businesses tackle these issues. There will also be the potential of jobs being created by this program, as IASME has agreed to hold training sessions on island to certify assessors. Our office is continuing to produce guidance. We will shortly publish a comprehensive guide to privacy that has dozens of pages of tips, checklists, and other pieces of advice. And even more guidance is coming on specific topics like privacy in a workplace context or detailed guides for individuals on their rights. I should also say, as the minister mentioned, PIPA is in line with the laws in other jurisdictions, and we work closely with our counterparts in those other jurisdictions, including places such as the UK, Canada, and US, to ensure consistency and interoperability with their requirements. Our office's outreach plan for 2024 will be dedicated to guiding organizations through the steps they need in order to meet the rules of PIPA. Starting on our annual Data Privacy Week in January 2024, we will provide the community with specific goals and actions to take each month as part of a phased action plan that puts the process of privacy compliance in bite-sized proportions. Organizations will need time to plan, so providing these sorts of concrete action steps within this extended window will allow the community to progress together. So I've often said that privacy is a journey and not a destination, and now we are all on the road to PIPA together, and I hope the community will take away the message that our office is here to support you. So, thank you very much.
Thank you, Privacy Commissioner. Thank you, Minister, for your remarks. This is the opportunity for members of the media to ask any questions. And Fiona, I'll turn it over to you.
Thank you very much. Thank you all. Fiona McWhirter from the Royal Gazette. Minister, you said this is a critical piece of legislation. You outlined some of the risks with regards to information that could get into the wrong hands. Why are we waiting now another 18 months for this to come fully into effect? We heard the legislation was anticipated to be fully in effect by spring of this year, and now we're looking at another 2 years down the road.
We recognize that there are some companies that are ready for this, particularly larger companies who are already dealing in and have business activities in environments and jurisdictions where this legislation is already in place. What we don't want to do is leave any of the smaller businesses behind. So we thought it would be wise to work with the Privacy Commissioner and provide the necessary guidance and training for those who still require it to ensure that come January 1st, 2025, that everybody is completely on board and ready and operating under what will come into effect on that date. It's not to say that you cannot function now. If you are ready, you go ahead and you have your protections in place, and that's great. But we have this as a provision so that everybody can be ready at the same time on that particular date.
Isn't there a provision within the Amendment Act, though, that allows for the legislation to be rolled out for different sectors of businesses at different times that would allow, enforcement now for some of those bigger businesses that do perhaps use this in other jurisdictions?
Well, we had that as an option. We also had the option to phase it in according to segments of the Act or to pick the one date in the future. That is more traditional, and under the recommendation of the technical officers, we've decided to go with the date in the future, the one date, and bring everything in one time. And hence we have picked a date in the future that allows sufficient time for those who may not be on board already to get ready for that and be ready.
The legislation was passed 7 years ago. Should businesses not be ready by now?
The legislation was passed 7 years ago, that's correct. The first thing that we had to do was to get the the Privacy Commissioner's office up and running. So without the office, there's an impossibility to implement the act. So you've heard briefly some of the things that were being done since we appointed the Privacy Commissioner in 2020. Continue to do that work going forward between now and January 1st, 2025.
Do you think that members of the public are really understanding the necessity for this act, or are we really starting to appreciate how important it is to have this in place?
I think they will. Those who may not have realized will, with the appointment of this date, will realize. But I will invite Mr. White to speak on that because he's been out in the community and conducting training and information sessions. So I think he's more qualified to speak on that than I am. So I would invite him to speak on that.
Thank you very much.
I would never say I'm more qualified than the minister at anything. Pardon me. So what I would say is about the community and the feeling of readiness is you have some organizations in the community that are more mature from an operational perspective in that they have some of these programs, whether it's cybersecurity controls or privacy controls, or even detailed compliance around anti-money laundering that has a lot of similarities because it also uses personal information. So those organizations, maybe they've had a requirement in another jurisdiction, and so they can see the value right away. For a lot of other organizations, though, I found in my time here that the conversation has really changed because over the course of COVID and us all working remotely and taking so much of our lives online, that we've seen that there's often a third party in between us and the other person, and we have to make sure that any secrets we tell the third party to tell the other person are respected.
Sure, thank you. And I'm not sure who'd be better placed to answer this, but with regards to a fee that businesses or organisations can charge individuals, any idea what that might be in terms of, when people are requesting personal information?
So there is a provision in PIPA that we can establish a schedule for what that fee might be, so what the maximum fee might be. Yep. That's a policy matter, so it'll be something that we have conversations with and have to do perhaps an economic impact to examine.
Sure, but presumably you've looked at other jurisdictions, what sort of ballpark are they working within?
Well, you have a different range. So for some jurisdictions, they say that, at one end of the extreme, that you cannot charge at all. Or if you are going to charge, there must be a reason why you're going to charge. And then the other, perhaps the other extreme would be, a kind of timekeeping method of how much employee time that it takes to do a certain thing. So that's the range of the spectrum that we're looking at. And the question becomes, what's the right balance for Bermuda?
Sure. Thank you very much. And this will be for the Minister. Just with regards to, we've touched on PATI. I know there's consequential amendments to PATI legislation with regards to this Amendment Act. Are you still looking at introducing a fee for PATI requests? And if so, how much will that be and when will it be introduced?
I will actually be making a ministerial statement on PATI tomorrow in the House of Assembly. So I would invite you to listen in on that.
You're not going to tell me now?
Tomorrow.
I appreciate it. Thank you all very much for your time. Thank you.
All right. Thank you so much, Fiona, for your questions. Ladies and gentlemen, that concludes today's press briefing. Thank you very much, Minister. Thank you very much, Privacy Commissioner. Thank you very much, Dr. Stones, for your time today.